Welcome back. Former Chief Justice of India, Uday Lalit, spoke exclusively to my colleague Ananya Bhatnagar on multiple issues. We here are getting you excerpts of that exclusive interview. Listen in to what the former CJI had to say about the Collegium system, what is the way forward as far as appointment of judges is concerned, and of course the SC decision on the Chawla rape case, which has now left the family completely devastated.
We are the only country probably which has a system where judges are appointing judges. We have a collegium system of appointments, but a lot of times the questions are raised on it. How do you think that it could be made better, or is there some change required in that?
See, the fundamental part, that is judges choosing their successors, is an established norm as a result of NJSC judgment. So therefore that is the law of the land. So that perimeter or the final boundaries of that jurisdiction or the idea are completely set. What one can still think of and try to improve the situation is where one can say that there must be certain timelines for certain actions. That is, if the recommendation comes from the Collegium at say 0 date, maybe within 2 months there must be a objection or the recommendation acceptance from the government. So therefore these kind of timelines, one can certainly, then that will be improvisation on the basic idea or character. But the basic idea is something which is an established norm, so therefore we can't go beyond that level. That is, the Collegium system is here to stay. We need to improve that to the extent possible, make it more functional, easily, and more accessible. That's how.
A recent judgment of yours on the last day attracted a lot of scrutiny on the social media. How do you like to comment on that?
This is a question getting repeated every time. You are the fourth person repeating that. So, see, that judgment which you are referring to, that death sentence getting commuted to where we acquitted the persons, correct? See, it was in the typical fact situation where, according to us, the guilt of the persons was not established. If the guilt of the persons was not established, there was no way that we could, give them death sentence. There was no way that we could hold them guilty. And that is the reason why we acquitted them. So therefore, it depends upon the fact situation. It depends upon what is presented before you as a case study, correct?
That was an exclusive reaction coming in from the former CJI on a verdict that has left not just the parents of Kiran Negi but the entire country devastated. He goes on to confirm to CNN News 18 that it is evidence that matters in the court of law and nothing else. And in this case, unfortunately, the prosecution could not establish guilt. We'll get you